Is my screen visible?
Yes. Now, yes.
Not visible.
Yes, it's coming.
Okay. Now I'm stopping this thing.
Not visible, sir, now.
Sir, not visible.
We'll share it again.
Yes.
Once we
Yes.
start, then we'll share it.
Yes, Astu. Huh? So, sir, shall we start now with
Yes.
invocation? Come. Om Sahana Vavatu Sahano Bhunaktu Saha Viryam Karavavahe Tejasvinavadhitamastu ma vidvishavahe Om Shanti Shanti Shanti. Pranam to all the participants. We welcome once again to our second day of our IKS TKDL workshop on traditional knowledge, digital life, traditional knowledge, intellectual properties, and pupils' rights. So today is the second day. Anil sir will take the session. His topic is actually intellectual property rights. IPR. It's a very core topic, and sir will talk about the fundamentals of IPR in the context of our traditional knowledge and Indian knowledge systems. What its classification, copyrights, patents, GI. So all categories will be discussed with case studies and examples. It's a great opportunity to listen, sir, regarding IPR. So we request all of you, please pay your attention and complete the session. After that, we'll go forward as assessment, 10 minutes assessment with 5 MCQs, then Q&A session. So Pranam sir, and sir extensive experience in law and property rights. Sir is also was an advocate, so it's a very good opportunity to know what are the laws involved in TK and IKS. So Pranam sir, what do you please start your session?
Thank you, Piyushi. Thank you for the kind introduction. So first I will share my PPT. Yes. So I hope my slides are visible to all. Namaskar. Good afternoon.
Yes.
Okay. So today it is the second day of the CSI TKDL IKS workshop. This is the 9th workshop that we are conducting, and we are into the second day, wherein we are going to discuss the fundamentals of intellectual property rights, and we'll also go through certain case studies initially. Then we'll have a multiple choice question test for 10 minutes, and we'll have question answer session after that. So hopefully we'll understand all the nuances of intellectual property system. So when we talk about intellectual property, so basically it covers the creation of mind. So when we talk about creation of minds, that includes the works of art. It may also include the scientific creations. It may also include music and other creative items that authors may do. So basically, when we talk about the creation of these scientific or artistic works, it requires a lot of labor, a lot of money and investment in terms of economics and the manpower. So basically, it requires a lot of investment that is to be protected. So when we talk about protection of these creative items, we should have certain laws that must prevent the unauthorized use In other terms, we can say that the authors or the inventors who are making these things possible, they should have a control over these items. So they can control the use of these items so that they get a fair return over the investment that they have made in terms of money and manpower. Basically, it's a cycle wherein you have to disclose what you have done. So if you take the example of patents, while you file a patent, you get a protection. In case it is granted, you get a protection for 20 years. But you have to disclose that patent invention to the fullest in the patent application. In other terms, you can say that once the term of this patent is finished after 20 years, somebody who is working in that field can make out that invention without any further R&D. So it's a kind of you disclose what you have and you get the protection over that item exclusively for a limited period of time. So this is how these new things come up. When we talk about culture, when we talk about economic development, or we talk about the improving the standard of life, this intellectual property system plays a very vital role. And when we talk about the laws which govern this IP system, we have different laws governing each item. So we'll be going through each item one by one, wherein one thing that I state before going to these individual items, that there are specific laws governing each item in each country. So when we talk about patents, so we have separate laws in India. We might have different, different law in US. Although the spirit is same, but we have minor differences in each jurisdiction. So in case you want to have a patent in India, you should follow the Indian law. And in case you want to file a patent get a patent in US, you have to follow the US laws, which may differ on certain aspects. So when we talk about intellectual property rights, this is the definition given by World Intellectual Property Organization, which says that intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols. It includes names and images also, which are being used in commerce. So these are some of the examples. First is the copyright law, which governs the literary and artistic creations. Then we have patents, which covers or protects the inventions being made by the inventors. Then we have trademark laws. These are commercial marks being used to distinguish goods and products. Then we have industrial design laws, geographical indications, plant variety protection, and so on. So we'll be studying these items one by one. So we'll start with patents. So as we all know, patents are granted for their patents are granted for products and processes which solve a technical problem which existed. Okay. So when we talk about a patent granted for a product, that means we have created a product which is superior in technical information over an existing product which was there, or we have developed or created a new way or process of doing something, and we have solved a pain point during that process. So basically these patents are granted for both products and processes. Okay. And we have already discussed the purpose also. When we talk about the purpose of patents, the prime motive of getting a patent is to have technological innovation protected that should promote further development. And these patents are granted for 20 years, as we discussed during the previous slide. All these laws are time bound, okay, and they are jurisdiction specific. So when we talk about patents, so the patents are granted for 20 years in India. So this is from the date of filing, and the other purpose is to document and publish the technical details of the patent application, so that after the expiration of these 20 years, a person who is having skill in that domain can work out that the patented invention for further development. So this is the basic scenario wherein you can identify the purpose and the things which are being protected. So this is the statutory definition given in the Indian Patents Act of 1970, which says invention is a new product or process involving an inventive step in which is capable of industrial application. So this is all about the basic overview of the patent. But when we talk about getting a patent for any product, there are certain requisites. There are certain, qualifications to be met. So when we talk about these requirements of getting a patent, the prime requirement is that the item or the process that you are getting patented, you intend to patent, should fall under patentable subject matter. It means that that subject matter should not be prohibited of getting patented. So each country has their own laws. So when we talk about the patentable subject matters in India, Section 3 of this Patent Act, it talks about the inventions which are not patentable. So it's negative in connotation. So whatever falls under the definition of invention is patentable, provided it should not fall in Section 3 that we'll be discussing in the next slide. Then another requirement of getting a patent is that the invention should be novel in nature. So if you want to understand the novelty, it means it should not be disclosed before the date of making the patent application. It should not be known to the public. So in case you came across an invention, you develop some new device which works in a very unique way and addresses certain existing problems. But in case you publish that invention before the date of making application for patent, then you kill the novelty of your own invention. Okay, so the essential requirement of getting a patent is it should not be disclosed in any form before the date of filing patent application. Then in case it is not disclosed, then it is novel and you can get a patent. The another requirement is that it should have inventive step. That means it should not be obvious to a person who is working in that domain. So there must be a technical advancement which is beyond normal working in that domain. So this is another requirement, and the last requirement is that whatever you are getting, whatever you are filing for patent application, it should be industrially applicable. There must be some kind of utility, some kind of use to that object. Then only you will get patent over the application that you have made. So as we discuss, these are the
Excuse me, sir.
Yes. Yes, please.
There is audio problem. Audio is very low.
Okay.
No, ma'am, it's okay to ask. Could you please check your device once again?
So you may try logging out and logging in again.
Yes.
I will try to be a bit loud, but you may check your connection
Voice
also.
is properly audible, sir.
Okay.
No problem in voice.
So in case you have an invention which falls under the definition given under the Act, still that invention is not patentable in case it falls under these prohibited categories, which is given under Section 3 of Patents Act and Section 4. Okay, so when we talk about the prohibited inventions in India is, first, frivolous inventions are not patentable. So when something is filed which is beyond, which is beyond the principles, scientific principles that we know, that is not patentable in India. For example, if we talk about a machine which is 100% efficient, that cannot be patented. We know nothing can become 100% efficient. Okay, there must be loss of some kind of energy in each process. So in case we file something which is violating the scientific principles, those things are not patentable under Section 3A. If we talk about Section 3B, it says something which is contrary to public order or morality, or causing serious prejudice to health of human, animal, or plant life or environment is also not patentable. To give you an example, if we develop something which is related to biological warfare or some lethal chemical weapons, which are seriously, they can affect the human health or animal health, those things are also not patentable in India. If you see Section 3, it says discovery of scientific principles or discovery of living things or non-living substances in nature are also not patentable. So in case we discover something which already existed, a new kind of metal, so that is also not patentable, or we came across some kind of scientific principle. So those things are also prohibited of getting patent in India under Section 3C. Discovering a new form of known substances or new use of known substances are also not patentable. This is applicable to the drugs and these medicines. So in case you know a substance and the substance can be used for treating a different disease, so those things are also not patentable. Okay. Then we have Section 3E, which says that mere admixture leading to aggregation of the properties of two known substances is also not patentable. So we have a decoction consisting of two plant extracts. So we know one plant is used for treating fever, and another plant is used for treating cough. So mere admixture of these two plant extracts leading to getting relief from fever and cough will not get patent, because we know that these two extracts individually were known for treating those diseases. So combining them will just lead to aggregation of the properties of these known substances. Therefore, it is not patentable in India. Under Section 3F, if you combine the properties of two devices, the working of two devices in a known way, that is also not patentable. For example, if you add the features of a fan and a light into a one device, then it is not patentable, because we know fan and bulb they work in a known way, which is and it will lead to only a combination of these two properties. Likewise, if you see Section 3H, it says methods of agriculture and horticulture. They are also not patentable in India. So in case we try to get a patent over the methods of plant breeding, so those things are also not patentable in India. Or some kind of process which is being used in horticulture, that is also not patentable, that is excluded of being patented. Under Section 3I, surgical, curative, prophylactic, diagnostic, therapeutic process, or the processes for treatment of humans and animals are also not patentable. Although some of the devices which are being used for this surgical process, they are patentable, but these processes per se, they are not patentable. Then plants and animals in whole or any part, they are not patentable. Okay, it include the seeds and their parts also. Mathematical, business methods, software, they are not patentable. Software are covered under copyright law that we will be discussing, but under Section 3K, these things are not patentable. Section 3L, it says copyrighted designs are also not protected under patents, because we have separate laws. For copyrighted subject matters, we have copyright law, and for design, we have design law in India. Then scheme or method of mental acts or playing games is also not patentable. Presentation of information, integrated circuits, we have a different law for integrated circuits. And most importantly, traditional knowledge or aggregation of known properties of traditionally known components is also not patentable under Section 3P. Sorry. So this was the exclusion given under Section 3 of the Indian Patents Act. And apart from that, under Section 4, atomic energy related inventions are also not patentable in India. So we can get the patent for any invention which exists, provided it fulfill all the essential requirements as we discussed in the previous slide, and it should not fall under Section 3 and 4 of the Patents Act. So if we talk about what can be patented, a lot, there is a huge list of process and products that can be patented. Some of the examples are given in this slide. You can get the apparatus, devices, machines you can get patents for these apparatus, devices, and machines. A lot of chemicals, they are patented. Drugs, food and their compositions are protected. Biological processes with the human intervention are patented in across the globe. Then you can get the patent for biological products also, and a lot of processes being used in manufacture. These are certain examples that can give you an idea of what can be patented. So this was all about the patents. Now we'll talk about industrial designs. So as you all can see, on this picture, so these industrial designs, basically they cover only the aesthetic view of the products. So in patents, we discussed that the technical feature of a product is covered or protected under patent, but under industrial designs, the aesthetic or ornamental aspect of a product is covered. It does not protect the functionality. Okay, so when we talk about certain products or most of the products being used in our daily life, we just select or choose the product on the basis of the appeal to our eye. So in case this, if you get, take the example of this shoe. So the look and the color makes a consumer to take a decision whether he should buy it or not. Therefore, in all these industrial products, aesthetics play a very critical role. Okay, so that is the reason there is a separate law which governs only the ornamental aspect of these industrial products which are being made uh, manually, mechanically, or chemically. Okay, so it's basically look or feel, no, aspect which is protected. So when we talk about the protection, so protection can be given for the shape, configuration, or the surface pattern, or it also covers the ornamentation. It may cover the composition of lines or colors, as you can see on this shoe. It basically the coverage is for an article, okay, and that article should have that industrial design applied through various processes. It can be manual, mechanical, or chemical process, and the item should have a commercial value for an industrial application. And that is, as I told you, it is only limited to the visual appeal of that article. So if for, to give you an example, if we have a watch which looks very attractive and it has a very distinctive or original features, making it different from others. But under this law, the coverage will be limited to the physical appearance of that watch. In case something is embedded in that watch, which is also aesthetic, but it can't be felt through the open eyes without opening that watch, then those things are not protected. It only protects which is visible to the consumer. Okay, and the essential requirement of getting a design is originality. So if you see the section 2G of this act, it says that originality in relation to a designs means originating from the author of such design and includes the cases which, though old in themselves, yet are new in their application. So to give you a better understanding, in case you have a design which was earlier applied to a curtain, and now you have applied the design to this shoe, now this design will become an original application of that design on shoe. So you can have two different registrations. One can be for that curtain that was existing originally, and same application of the design on this shoe will have a separate registration. So under this law, these are some of the items which are not registrable. Okay, as I already told, designs applied to the inner portion of the article which are not visible or noticeable are not protected under design, this industrial design. It also excludes the building and structures. It also excludes a part of an article which can't be sold separately. Okay, so if in case you have an article which has two components which can be sold separately, then you have to get registration for those individual items separately. Okay, and the variation in the variations used in the common trade are also not registrable. So different sizes of a same product, you can't get separate registrations. Okay, stamps, labels, tokens, medals, trademarks, cards, cartoons, these things are also excluded from registration under industrial designs. Then change I already discussed. Then you can not get protection over emblems, national emblems, or flags also. And lastly, the computer chip, we know them by the name of integrated circuit design. Those things are also not patentable because we have a separate law that we'll be discussing in the coming slides. So like patents, this industrial designs has also a limited duration. So the design registration and this protection is granted for a period of 10 years, which can be further extended by another 5 years by an application for renewal. So maximum coverage under this law is 15 years. Okay. So this is another tool which is being used in intellectual property regime. So this is known as trademarks. As you can see, some of the marks which are you already know. One is of Tata Motors, then we have Pepsi. These are some of the well-known marks which are being used to distinguish the product and services of one from the other. Okay, so this law is very important in trade and commerce because the manufacturers and the service providers, they use these marks to make the consumer aware that from where these products or services are being offered. Okay, and it becomes very important for these enterprises to protect these marks. So these marks are being protected under trademark law. So each country, they have their own trademark law. In India, we recognize the registration of trademarks under the law that we have, and also through common law. It means you can get your trademark registered under the Trademark Act, or in case you are using your trademark for a very long time, then you have a common law created in that mark. But it is, since we have a dedicated law, it is always advisable to get your marks registered and before the trademark registry. So it's a very strong marketing and branding tool which is being used, and it may consist words, designs, signs, symbols, shape of goods, packaging, color or combinations, or any combination of these listed things. So these are some of the some more examples of the trademarks that you can see. And the term of protection of trademark is initially for 10 years. So when you make an application for getting your trademark registered, initially it is granted for 10 years from the date of making that application. But the best part of this trademark is you can renew this protection, the application for further 10 years, and this can be done till you want to use it. Okay, so it's like in case you want to use it for 50 years, 60 years, you can get it renewed every 10 years. And these patents, designs, and trademark items, they can be licensed or assigned partially or completely. So they have economical rights attached to them. So if you talk about some unique examples, this is one of the examples that I have taken from Kenya, wherein the trademark law is used to make their product attractive. Okay, so apart from the normal trademarks, we have collective marks also. So the difference between a normal trademark and the collective trademark is like, in normal trademarks, the ownership can go to a person, company, sorry, company or some mixed authors. But for these collective marks, you have a group of owners which own. So these Toyota baskets of Toyota County, these baskets are very unique. They are traditionally made, and the ownership of the trademark of this basket is owned by a group. Okay, and the unique thing about this product is like these are made up of sisal plants. They are traditionally made from they are being made from very long time, wherein the processing of fibers and weaving, all these standards they have fixed the standards how these things will be made to meet this specific quality standards. So they cover basically two things. The trademark is owned by a group of manufacturers, and they have specified certain kind of standards so that the quality and the reputation of this product remains in the market. So that's the reason these baskets and the association which owns the trademark, they have given immense customer confidence and recognition. And this is also one of the examples wherein trademark law is being used to preserve and protect the traditional knowledge. Okay. So now we'll discuss about the geographical indications. So basically, if you talk about geographical indications, we see a lot of examples of GIs. The best example is Darjeeling tea. Okay, we all know that Darjeeling tea, it originates from a specific state. Okay, and it has a specific reputation also. So from this example, we can identify the characteristics of the geographical indication. Basically, these indications, they are used by certain products which originates in a specific geographical location, and they have some kind of reputation or quality attached to their origin. Okay, so there are three essential parameters. One, the origin should be in a demarcated region. There must be a quality or reputation of that product, and that reputation or quality is essentially linked to that origination in that geographical location. Then only these geographical indications are registered. Okay, and these are given for products only. There is no GI protection for services. Okay, so you have a lot of examples of GIs coming across several, I mean, all these states. Okay, and when we talk about the protection of the GIs, initially, like trademarks, it is granted for 10 years, which can be further renewed for 10 years till you want to use it. And they are tradable commodities. You can assign license, the rights to the licensee or assignees in full or in part. Okay. So when we talk about GI, geographical indications, there are basically three categories. First type of GIs are agricultural based products. So some of these are some of the examples which have been given on the slide. Darjeeling tea, Guntur Sannam chili, Ero turmeric. These are the agricultural products which are protected under GI law in India. Then we have certain items which occurs naturally in the environment. So these marbles and those things are comes under this natural category. And the most important or the widely used category is manufactured products, which includes handicrafts, manufactured industrial goods, and foodstuffs, which includes a lot of textiles, ceramic pottery, and all those items which are being manufactured by hand or through some kind of special skills. So this is the overview of the key attributes which are essentially required for getting a geographical indication for a product. So as I already mentioned, there must be a geographical area, a designated origin, a place where that product or process originates. So there must be a particular geographical area. When we talk about processing of that product, at least one stage of processing should take place in that designated area or the defined area. And you have to submit the map of that territory or region along with the application. Another thing that we discussed was the reputation of product. So the reputation must be a distinctive reputation in terms of goods, nature of goods, quality, and that there must be established repute. It can be domestic or global or any other characteristic feature. Okay, and these two things should be linked. So the given quality should be linked to the geographical environment, locally sourced material, or some kind of human factors. So when we talk about Banarsi sarees, so there is a special skill that exists in the artisans located in that geographical location. So until or unless any of the process of making those sarees is not performed in that location, then that product cannot qualify to be a geographical.
Sir, you are not audible.
Sir, you are not audible.
Sir, you are not audible, sir.
Am I audible now?
Yes, yes.
Someone
Now you are audible.
just muted
Please
me.
share your
Please
PPT
don't
again.
please don't mute me. It is a humble request. Please. Am I audible now, Yoshi?
Yes.
Let me share the slides again. Are slides visible?
Yes.
Yes.
Yes,
So this
sir.
was the slide I was talking about. So these are the key attributes which talks about the geographical area, the reputation of product, linking that reputation to that geography, the product and the geographical area and the uniqueness. Apart from that, you have to submit details of the applicant also. So this is one of the example wherein an application for Bangla Rasgulla was filed by one of the states, and it was opposed by another state stating that it belongs to us. But while the application were examined, the contention of both the states were heard, it was recognized that these two products are different. Okay, so when we talk about Bangla Rasgulla of West Bengal, it is different from the Odisha Rasgulla. So they are different in their historical origin, they are different in color, texture, and taste also. So technically, these two products, they both qualify to get registered as two different GIs. So this was the whole dispute, and the conclusion that was given that these two products can register separately. So now both Bangla Rasgulla and Odisha Rasgulla are two different GIs filed before the GI registry. This is another example. People from Konkan region, they know about these Warli paintings. This is a kind of linking the traditional knowledge to modern contemporary use using these tools. So in these Warli paintings, people from that region, they know that these paintings are made on mud walls with white paste. And the paste which is being used for making these paintings, they are traditionally made. They comprise of rice, water, and gum. And the brushes are made up of bamboo sticks. They use them as paint brushes. Okay. And these paintings are made during specific celebrations wherein they sing song and stories are being made on the walls. So this is a kind of very unique art that they make. And if you see the GI application that is made for this Warli paintings, it is made to apply these paintings on paper under class 16, paper, cardboard, and plastic, and on wood, plywood, and furniture under class 20. And class 25 covers canvas, cloth, and garments. So basically, these Warli paintings, which originally were used on walls or painted on walls, will now be applied to these items covered under class 16, 20, and 25. So this is how GI is just helping the economic development of the people also. So the another example or the tool that we will be discussing is the copyright law. So this copyright law is basically known as author's right, which covers a wide range of articles or items, such as which covers literary, artistic, and scientific creations. Okay. So apart from poems, stories, and novels, it covers a lot of other items like movies, songs, choreographic works, paintings. So it covers a wide range of items, and the basic coverage is like all works of authorship are protected under this copyright law, and it protects the expression of ideas. Okay, something which is expressed is protected, and in case you have some ideas in your mind which is not expressed in a tangible form, that cannot be protected. So all expressions of creativity are protected under copyright law. So as I told you, it covers literary works, which includes poems, stories, novels, books. It covers dramatic works. It covers musical work and artistic works. And essentially, these four items which falls under original work should be original in nature. So when we talk about originality, that means it should not be copied from others. It should be a true work of the author. Although when we talk about cinematographic film, we all know that cinematographic film is a combination of these original items. Okay, so we can combine a literary, dramatic, or musical work to form a cinematographic film which combines all these. But essentially, these items individually should be original. So this is the whole system wherein copyright law works. And these are some of the examples. If you see the books, the dance forms, okay, the paintings, this is the famous sand painting. So all these things are protected under copyright law. So when we talk about copyright law and the benefits under this law, it talks about three kinds of rights that one has. So first is like, in case you have got your item registered under copyright law, or you have got the rights under copyright law, you have economical rights of governing the use. Okay, so you can govern the reproduction of the work. You can control the distribution of copies of that work. You can also control or regulate the public performances of that work. In a way, you have the right to regulate the broadcasting, translation, or adaptation of that work. So all these activities, they fall under economical rights, and you get monetary benefits out of this economical right. Okay, so you get money, You get fair return on your investment made. The unique thing of this copyright law is, apart from these economical rights, you get certain kind of moral rights also. These moral rights are separate from economical rights. For example, you get a right of attribution. So although you have transferred your rights to somebody else, to the licensee, but you still have moral right of attribution, wherein you can say and claim that this work belongs to me. So you have a right of attribution. You have a right to prevent distortion of the work. So when you transfer your rights, somebody else should not use that work in a different way. You have seen various examples of movies wherein the whole story is twisted, and the authors, they have filed suits and petitions claiming that you should not distort the original nature of that product. Okay, then all these things are covered under moral rights. Apart from that, this law has performers' right also. So these performers' rights, they cover the rights of live performances, the performances made by the authors or the performers. Okay, and when we talk about the using all these rights, then each country has their own laws which govern the infringements or the usage, unauthorized usage of that product. So these remedies may be civil in nature, which includes injunction, damages, accounts, or cost. It may be criminal, okay, and there can be administrative measures regulating the unauthorized use of these infringements. Each country has its own specific law to take care of this unauthorized use. So this is another tool wherein we will talk about the plant variety protection. So for protection of plant varieties in India, we have a specific law which is known as the Protection of Plant Varieties Protection and Farmers' Right Act of 2001. So the whole regime of this plant protection is built and governed by International Union of the Protection of New Varieties of Plants. So it is an international agency which harmonizes the laws of protecting plant varieties across globe. Although India is not a part of this union, but we have adopted the basic tenets of this model law. And apart from that, the law that we have enacted in our country is UPOV Plus, wherein we have considered the right of farmers, breeders, and researchers. So this is a very unique law that complies to the international obligations in addition to the need of our country. So when we talk about the protection of plant varieties, the essential requirements that are needed to getting a variety registered is distinctiveness, uniformity, and stability. So when we talk about a plant variety being protected under this law, it must be distinctive. It must be distinct in terms of characteristics expressed. It must be that these characteristics should be uniform across generations. So when you say that this variety of flower gives us unique color, then the expression of that color should be uniform in subsequent generations. Okay, and there must be stability in expression. Then only that specific variety for that flower will be protected under this law. So if you talk about the kind of plant varieties that can be registered, so in Indian law, we have new varieties that can be registered. We have extant varieties, farmers variety, and essentially derived varieties. So this chart provides you the essential criteria for registration, the rights which are conferred, and duration of protection also. We'll share these slides with you so you can go through these parameters easily, readily. So we'll not go much into much detail. We'll not talk about the detail this thing, but you can go through once this slides will be shared with you. So this is one of the unique, a different kind of law that we have, which governs and protects the integrated circuits. Basically, it protects the layout design of the integrated circuits. So if you see the back of this laptop, you all might have seen the intrinsic characteristic features of some kind of electronic equipment. You see a kind of board which has different integrated circuits, transistors, and various elementary circuits which combine all these elements. Okay, and we know that making a product smaller requires a very high quality of intellectual skill to arrange all these things. So this is where this law plays a very important role, because arranging these integrated circuits, transistors, and making this thing work, it requires a specific skill which should be protected. So the layout of this design is protected under this specific law that we have. And these elementary circuits, these electronic circuits, can be seen in most of the electronic or electrical equipments that you use in your daily life. Okay, and the protection is given to this layout design which you see on this slide. Okay, so the coverage is for the product, but the protection is given to the arrangement of these slides, and this map is registered there. This is known as layout design, which outlines or describes the integrated circuits comprising the transistor and LED device connecting in a specific way. So when we talk about the essential requirements of getting a layout design registered, then it should be original. Originality means it should not be known to others. Okay, and it should have intellectual efforts also. So the two items that you see in orange, these are exclusions. Okay, and it should not be commercially exploited before the 2 years, I mean, from the date of application. And the essential requirement is it should be inherently distinctive. It should be distinctive from the existing maps. And it can be, when compared with others, it can definitely stand out. So it should be capable of being distinguishable from the existing layout designs. That means in case you are combining 2 or more layouts, then they should not be strikingly similar. There must be some kind of intellectual effort being put in. Okay, and if we talk about the duration of protection, I mean the duration of protection, it is granted for 10 years from the date of making the application. And for these copyrights, we missed to tell you that the protection of copyrights is like 60 years after the death of author. For copyrights, it is 60 years starting from the 1st January of the next year when the author dies. It's a very long for copyrights, but for the semiconductor integrated circuit, it is 10 years. So this was all about all about various tools that are being used in IPR system to protect your intellectual creations. This slide gives you a summary wherein it talks about copyright and related rights, wherein it covers literary, musical, and artistic works. There are certain examples given. Patents covers inventions. Trademark comprising certification and collective marks. They covers the signs being used by the commercial houses for their products and services. We also talked about GIs, which are the signs used on products for originating in a specific jurisdiction, having a specific reputation. Then industrial designs are granted for aesthetic or ornamental looks of a product, layout of integrated circuits for these electronic circuits, and we also talked about plant varieties. So in all these laws, we have seen certain kind of conceptual similarity. So there is a similarity between these laws in terms of the subject matter, that is either product or process is being covered. There is similarity in the criteria of protection also. So they have to fulfill certain essential eligibilities. All these laws, they confer exclusive rights also. That means the owner of that IP can regulate the use of the rights. There are certain limitation and exceptions under each law, and there is a time limitation also. These rights are given for a certain period of time. And when we talk about the differences, then each law covers a different subject matter. We have seen that patents cover the inventions, copyright covers the authorship works, industrial designs covers the aesthetic view. Then when we talk, and another thing is there are certain requirements of grant also which differs. So when we talk about patents, it should be the invention should be novel, non-obvious. However, when we talk about industrial design, there is a condition of originality. So those are the specific conditions under each law. Then there are differences in the nature of rights being granted, and there is a difference between duration also. So to end with, this is the summary. We all have seen that IPRs, they basically protect the creativity of the person who is making the investment in terms of money or labor. And we see two kind of IP tools. One which protects the creators, another one is which creates the consumer also. So when we talk about patent designs and copyright, they are basically towards the protect. They are basically enacted for protecting the creators. However, if you talk about trademarks and GIs, they are basically protecting the rights of consumer also. Okay, and these are being used for branding purposes. And the whole idea of giving you this presentation is that whatever you do, be it a artistic work or a scientific creation, you can create those works into assets which are tradable. And in case you use those products for commercial purposes, then you can have an edge over the others. So this was the whole thing, and I hope you all got an idea of these types of tools which are being used in IP system. Thank you.
Thank you, sir.
Yushi, are you there?
Yes, thank you, sir. Pranam. Thank you for your informative session. So, sir, with your permission, could we complete the assessment quickly? Then we'll
Yes,
come back to
yes.
Q&A session. So, we are sharing.
सर असेसमेंट लिंक कहाँ पे मिलेगा?
Assessment link is in the chat box. Can you just access the link? I will share the link also. Okay. So in case you can't access that in the chat box, you can just type this link in your browser also. Let me just share it.
Sir, what about yesterday's quiz?
Can you see the link? You can just type it in your browser.
Uh, Respected sir, actually I am not getting the link for quiz. Can you paste once again, sir? Hello. Okay, thank you, sir. Sir, it's not working, sir. Paul, sir. Sir, once again, send the link, please, sir. Sir, I'm not able to connect with this link, sir.
Sir, sir, you are on mute.
There is the question with me. I'm not able to connect with this.
Sir, it's requested to you. Yes. Pardon, sir, but it's the request to you, sir. Kindly share the link once again. I am not able to keep. Okay, sir. Okay, thank you.
Biju, sir, actually yesterday's link, is it available for submitting the assignments? Because I couldn't be able to submit yesterday. You are on mute, sir. Again, you are on mute.
No, ma'am. So time is out. Please follow. Please complete of the assignments. It's okay. Okay.
Oh.
Leave that one and do from now onward.
Yes, sir. Yeah, today's it's
Today
completed.
onward. Please complete all the assignments.
Yeah,
You need 75% marks. Yes,
Okay.
please complete.
हेलो
Yes, Amit ji.
सर आप एक चीज चेक कर सकते हैं क्या मेरा नाम रजिस्टर्ड है आईकेएस के वर्कशॉप 9 में
Sir, please send the requisition, sir, on your slide, sir. I cannot keep just link, sir. Just share, sir, on your screen.
Yes, 1 second.
Sir.
I'm
Just a
sharing.
screen on his.
Yes, 1 second.
Just sir, show on your screen, sir.
Just sharing, no? Just give me a minute.
Sir, excuse me. So actually, yesterday I had submitted the question Google form a bit late. Hope that's okay. But I got the response being recorded.
If you have submitted, don't worry. Astu?
Okay. Okay, thank you.
सर वो जो लिंक सर थोड़ा सा स्क्रीन में शेयर कर दीजिए ना 1 मिनट हम टाइप कर लेंगे सर स्क्रीन में सर
Yes. Sir, I think Anil sir has shared. Please see. We have another 2 minutes, then we'll start.
Sir, for the yesterday and today, I have submitted the assignment. But tomorrow, we have PhD interviews happening here, tomorrow, day after tomorrow, at this time. So I can only hear the recording and submit thereafter. Sometimes interview we
Hello,
have.
excuse me, sir.
No, please manage 10 minutes. So
No,
you
no.
will have links and we'll also upload in the Google Drive also at the
So
same time.
class also I may have to hear little later in the evening because during till 5 o'clock
Please
interview.
manage. Yeah,
Right
please
now,
manage. Please manage.
is available
Or
in Google Drive also.
From there, sir, in the evening, I can hear and submitted everything nicely.
Hello, excuse me, sir.
some questions we can take. Yes.
One question, sir, which is there. Do we need to have a separate trademark for IKS? Something which is indigenous knowledge system. Now everybody talks about it, and there could be a lot from IKS people talking from one end to another end. So do we need to have a trademark for what is IKS and what may not be, or some system to set up within India?
Sir, trademarks, they are granted for the marks being used to specify a certain kind of product or services. Yes, no doubt IKS is offering very good services. So they qualify this IKS, both the name and the logo, they qualify to get a registration under trademark law. Provided, as I told you, there must be a certain kind of link also with IKS. So Indian knowledge system being a very generic word being used previously also. So in case IKS creates a kind of goodwill which is directly linked to IKS AICT, then they will get the registration. But yes, to answer you, it qualifies to get a registration under trademark. And PUC should work on it to get a registration.
Yes.
Yes.
That's a good idea.
Okay.
Excuse me, sir.
I have a question.
I have a question. May I ask, ma'am, or you wish to ask Dr. Priyanka or something? Can I continue? Okay. So, if there is a combination of a drug which is already approved, and if we are adding another drug to it, the indication of which is not established yet, so will that patent be eligible? What is your opinion, sir?
See, first thing is you are combining 3 ingredients. Okay. So combination of 2 ingredients is known. This is your question. Okay.
No, sir. There are 2 drugs. One is known and the other one is not very well known, and the indication for which the second drug is getting used, that indication is not yet being established.
See, when we talk about novelty, तो वहाँ known is well known की बात नहीं आती है. The only reason is whether it was disclosed before the date of application or not. In case both the drugs, they are known before the date of filing the patent application, then the novelty is not there.
And what about the indication, sir? If the use is not established, then if the use of that drug is not established, then
so you have now, your question is like you have a new use of the existing drug.
Yes, exactly, sir. Exactly.
Okay. So in case you are using a specific product for different use, so you have to fulfill the essential parameters given under section 3D. So if you go through section 3D, it gives you the essential requirements for getting a existing product patented for new these things. तो वो आप थोड़ा डिटेल में देखेंगे तो you will get to know. Okay.
Thank you, sir. Thank you.
May I ask a question?
Vinay
Yes,
Kumar.
yes, Priyanka ma'am, to be continued.
Oh, sir, I have registered myself, but I didn't get any mail from your side. So now I am recently using this from my friend's link. I am joining this. And I have mailed the TK, this site, official site, that I haven't get my mail or any registration link. So is there anything, sir, that I can do about this?
Yes, ma'am, please write to once again to our mail workshop at iksindia.org. There may be some technical issue. When we send bulk mail, there may be cause of bouncing mail. Some mails are another problem. You have put manually your email ID in the registration form. If there is any typo by chance, that may be the cause for not sending your mail. So please write to our workshop at iksindia.org. We will reshare the link. Okay.
Okay, sir. Thank you, sir.
Sir, I have a query
Namaskar, sir.
regarding IP patent.
Yes, please.
May I continue?
Yes, please.
Thank you,
Yes,
sir.
yes,
Thank
ma'am.
you.
Call the name, please,
Yes, sir.
please, Aarti ji.
I'm,
So I will
yes,
call
I'm
one by one, then you can start your questions. Astu?
sure.
Aarti ji, please.
Okay, thank you,
Proceed.
sir. Sir, actually, I want to know if I have applied for a patent certificate and I have followed the process, the first process, the registered, and then I have got publication in the journal on the website of Government of India. Sir, I want to know that what is the next process to get the certificate for that patent and how long it will take time to get certified and whether it will be certified or not after getting the publication in the journal of Government of India website.
Yes, patent application takes some time to get registered. So the first stage is you file a patent application. Second stage is it get published in the journal. Then you may request the patent office to get it examined. Okay. So until or unless you are not
Okay, sir.
making an application for getting that patent application examined, then it will not be examined. Okay. So then
Okay,
it will
sir.
be
Okay.
examined by the patent office. In case there are objections which need to be fulfilled, they will communicate to you under FER,
Okay, sir.
first examination
Okay.
report. You have to comply with those things and fulfill their basic requirements. And in case the patent office is satisfied, then they will process it further for grant. In
Okay.
between, there are
Okay, sir.
certain other
Thank you.
provisions also that I am not discussing because it's a very lengthy process.
Yeah.
So, but after
So, sir,
publication,
I want
in
to know,
case,
is there any use of patent publication in journal as in academia?
yes, the whole objective of publishing a patent in journal is like when you're filing a patent application, you're getting certain exclusive rights against the society. So you will
Okay.
exclude the whole society, and you will get certain exclusive
Okay,
rights
sir.
for 20 years. But the society should know what kind of rights you are getting. So in case I feel like you have invented something which is already with me, okay, so I can oppose your patent application.
Okay, sir.
So
Right.
this is the kind of communication to society because a balance has to be created in terms of the rights granted to the patent applicant and the society as a whole. Because
Okay.
these rights are not in rem, these are against the society.
Also, one more question, sir. Is there any difference between utility patent and design patent?
See, this concept is not Indian.
Okay.
In Indian law, we have patent rights under patent law, and we have Design Act enacted for protecting designs. So this is something which you have read somewhere. I mean, it belongs to US, I believe. So each country has different laws, but when we talk about India, inventions are protected under patent law, and designs, they are protected under Design Act, Industrial Design Act.
Right, sir. Thank you so much. Thank you.
Sir, I have a query, sir. Can you explain Kapila scheme, sir?
Can you
Kapila,
please couple of?
Kapila scheme. Because in IPR, when we filed, afterwards we can get back the money through Kapila scheme. Can you explain that, sir, little? How it will be?
No, I'm not getting it. Couple of, there is a, I mean, disturbance.
Kapila scheme. Kapila. Kapila scheme.
Kapila scheme for patent publication.
Acha, Piyushi, this
Yeah.
question is for you.
Kapila's scheme for patent application. I am not aware of this. I have to check it out. So let me, I will check and reply through mail. Okay. I am
Okay,
write
sir.
down your question.
Thank
Kapila's. Okay.
So Dr. Jitendra Bhavsar here, Atal Bihari Vajpayee Hindi Vishwavidyalay. Just I know too about the patent publication scheme is suppose some of the apparatus are prepared in the ancient era by our scientist, and if we will prepare again with the different material, so can we go for the patent or not?
You're talking about something which already existed in our
Yeah.
ancient, this thing, and you are improving it further to get a patent. Okay.
Yeah. Yes.
Yes. So as I told, in case you are filing a patent application, it should not be known previously.
Okay.
This is the first requirement. So in case your invention is exactly same to what has been disclosed earlier, so there is no novelty. You don't fulfill the essential parameters. Additionally, in case this is something which is traditional knowledge, in effect is traditional knowledge or aggregation of properties which are already known in traditional knowledge or being practiced by others, then although it is an invention, but section 3p, it says those things are not patentable in India.
Yes.
This is second thing. But in case you have made improvements over the existing knowledge, okay, and that is not obvious, then definitely you will get a patent. And obviousness is like, in case you are talking about making a formulation for treating cough, okay, then
yes, sir.
The existing knowledge or the existing, the traditional knowledge that is there, you have added certain kind of improvements in that decoction, which has enhanced the efficacy of that product, then you will definitely get the product, this patent over that.
Thank
So
you.
this is the whole kind of scenario which governs the grant of patents over existing knowledge.
Hello, sir. Am I audible?
Excuse me, sir.
Yeah. Hello. Am I audible, sir?
Yes, please.
हाँ, sir, मेरा question ये है, you were talking about the plant varieties and the patentability of the plant varieties. I just want to know that कि कोई plant variety है जो कि natural है but it is not being known. और अगर मैं उसको आइडेंटिफाई करता हूँ, जैसे मान लीजिए कोई मेडिसिनल प्लांट है, मेडिसिनल प्लांट की बहुत वेराइटीज होती हैं, कहीं लोअर एल्टीट्यूड पे, हायर एल्टीट्यूड पे, अब वो कोई वेराइटी है जो नोन नहीं है and it is having better secondary metabolite content or it is better in something something of like treatment of some diseases, so whether that type of variety will be patentable or not, like it is natural, no genetic modification or breeding or whatever other scientific methods they have been not used in the improvement of that variety, so will that variety will be patentable or not?
नहीं, देखिए, I gave you a very detailed presentation wherein I told you that plant per se and plant parts are not patentable. So we have a different law which governs the protection of plant varieties under
Yes, sir. Yes, sir.
PPV FRA.
Yes, sir.
तो पहला तो ये है कि we don't get patent for plants in India. Okay.
Okay.
Another question आपका ये है कि you have a improved variety
Yes.
of existing variety, है ना?
Yes, yes.
Definitely you can get a registration for that improved variety, but you have to fulfill 3 basic criteria जो हमने बताए थे आपको, है ना? It is DUS, distinctiveness, uniformity, and stability.
Okay.
तो जो characters आपने डेवलप किए हैं, the improvements which you are talking about, they must be distinctive enough as compared to the existing.
नहीं, जैसे मैंने मतलब मैं ये कह रहा हूँ कि हमने कोई मेथड भी नहीं लगाया, कोई हमने जेनेटिक मॉडिफिकेशन नहीं करी, हमने कोई ब्रीडिंग नहीं करी, वो वैरायटी नेचुरल है बट वो अवे मतलब पहले नोन नहीं थी ये वैरायटी.
ठीक है, ठीक. नहीं, आपका क्वेश्चन ये है कि आपने कुछ नहीं किया है, you have just filed. तो माय क्वेश्चन इज, क्या ऐसे में आपको राइट मिल जानी चाहिए?
मैं वही सर आपसे क्वेश्चन करना चाह रहा हूँ कि नहीं, जैसे आईपीआर की जो आप बात कर रहे थे ना प्लांट वैरायटी प्रोटेक्शन में, या जो ब्रीडर्स राइट है, यहाँ पे मैं रिसर्चर्स राइट के बारे में थोड़ा जानना चाह रहा था। फार्मर राइट का भी आपने बात किया था, ब्रीडर राइट की बात करी थी, रिसर्चर राइट मतलब जो ऑब्वियसली बात है कि कोई बॉटनिस्ट है या कोई और लोग हैं जो आइडेंटिफाई करते हैं, कोई ऐसे जगह पे जाते हैं जहाँ पे नहीं जा सकते, लोगों ने एक्सप्लोर नहीं किया है, प्लांट वेराइटी है अवेलेबल लेकिन इट इज नॉट एक्सप्लोर्ड एंड इट इज नॉट बीइंग रिपोर्टेड। मैं ये कह रहा हूँ कि रिपोर्टेड नहीं, जैसे आप बता रहे थे कि पहले से रिपोर्टेड नहीं है, तो उस केस में क्योंकि एक प्लांट तो है, मान लीजिए कोई प्लांट, आपने कोई चिरायता प्लांट ले लिया, अब चिरायता जगह चलता है, जो अगर साइंटिफिक नेम लेके भी हम चलते हैं, वो चिरायता अगर कहीं ऐसी जगह से मैंने निकाल लिया जो डिस्टिंक्ट है इन टर्म्स ऑफ सम प्रॉपर्टीज है, जो भी उसका मार्कर कंपाउंड है उसकी
बिल्कुल जायज है ना। इस तरह का सिनेरियो हम लोग बना सकते हैं, बट व्हेन यू फाइल एन एप्लीकेशन यू हैव टू सबमिट अ लॉट ऑफ इंफॉर्मेशन जो आप एज ए डिस्कवर्ड उसके नहीं दे पाएंगे, है ना। बट ये एक्सटेंट वैरायटी में रजिस्टर हो सकता है डेफिनेटली, बट यू हैव टू सबमिट द डिटेल्ड इंफॉर्मेशन, और उसकी फिर डस्ट टेस्टिंग भी होती है। सो ऑल दोस पैरामीटर्स यू हैव टू फॉलो। अभी आपसे हम स्लाइड शेयर कर देंगे, उसमें सभी वैरायटीज को अलग अलग डिस्क्राइब किया हुआ है, जो एसेंशियल क्राइटेरिया है सभी का, दैट इज आल्सो लिस्टेड देयर, एंड व्हाट काइंड ऑफ राइट्स आर गिवन।
ठीक है सर, ठीक, ओके।
Hello sir, am I audible? Hello sir, am I audible?
Thank you.
Yes, yes.
Yeah, this is Dr. Payal Dande from JSPM University, Pune. And my question is, we have developed a novel formulation using different plant extracts for a cosmetic use. How can it be patented, and if yes, how?
Yes, definitely it can be patented, provided it fulfills all the essential requirements. First essential requirement is it should be a patentable subject matter, जो वो है। दूसरा है it should be novel in the sense कि it should not have been disclosed previously. Okay, अगर वो ऐसा है तो it is novel, then it should not, then combining those ingredients should not be obvious to a person who is skilled in making those decoctions. नॉन ऑब्वियस नहीं होना चाहिए, और डेफिनेटली उसका जो है यूटिलिटी तो है ही है ना। तो ऑल दीज 4 पैरामीटर्स आर मेट। जो दूसरी रिक्वायरमेंट है वो है इट शुड नॉट फॉलो अंडर सेक्शन 3P। अगर वो ट्रेडिशनली नोन आइटम है तो इट विल गेट रिजेक्टेड अंडर सेक्शन 3P। तो ये
प्लांट एक्सट्रैक्ट्स तो यूज किए हैं, बट वो ट्रेडिशनली नोन फॉर दिस पर्टिकुलर यूज नहीं है।
Then definitely it will get.
ठीक, thank you sir.
सर माई सेल्फ डॉक्टर मनोज कुमार त्रिपाठी। सर मेरा एक प्रश्न ये है सर कि जैसे कम्युनिटी बेस्ड ट्रेडिशनल नॉलेज है जो एक कम्युनिटी के पास है, और वो उन्होंने पेटेंट नहीं कराई है और कम्युनिटी पेटेंट कराना चाहती है, तो मान लीजिए अगर मैं उसको इनिशिएटिव करके पेटेंट कराना चाह रहा हूँ कम्युनिटी के साथ मिलकर, तो किस तरीके से उसको इनिशिएट किया जा सकता है सर?
सर आई विल रिक्वेस्ट कि आप इस क्वेश्चन को संभाल के रखें। नेक्स्ट 2 days we'll be discussing on this aspect only. So we'll have detailed presentations covering all the aspects, है ना। तो community knowledge, how to regulate those things, वो सारी चीजें we'll discuss in detail.
Okay, thank you sir, thank you.
Okay.
Hello sir.
Yes sir, so we can take another 1 or 2 questions. Yes, please madam, proceed.
Am I audible?
Yes.
Hello sir, this side Vinita. I'm research scholar in Central University of Jharkhand. Sir, actually I am thinking to do research with the tribal community, and I want to study their tattoo culture, tribal tattoo culture. And I also want to connect their tribal tattoo with the IPR, but I don't know how to connect them. So sir, please share some thoughts.
Okay, first thing is you're talking about an art form, making tattoos.
Yes, yes sir.
First you have to identify which IPR tool is best suited. Okay, so when you talk about tattoo, it's a kind of expression. So once you make that tattoo, it is a copyrightable subject matter, the express tattoo.
Okay sir.
तो ये एक चीज हो गया, but that covers only the product. है ना। तो जब आप टैटू बना देंगे या वो डिजाइन कुछ प्रोडक्ट पे अप्लाई कर देंगे, देन ओनली यू कैन प्रोटेक्ट इट, ठीक है। बट दिस आर्ट फॉर्म जो है ये जीआई भी रजिस्टर हो सकता है, जीआई रजिस्टर नहीं होगा ये, पर टैटूज यस डेफिनेटली अगर वहां बनते हैं तो देयर मस्ट बी सम काइंड ऑफ यूनिकनेस अटैच्ड टू दैट.
Okay,
then
sir.
you can explore of registering it, registering this tattoo under GIs also, है ना। तो वो देखना पड़ेगा आपको, बट कैसे करना है ये हम लोगों की डिटेल प्रेजेंटेशन होगी नेक्स्ट 2 days. सो उसमें फिर आपको थोड़ी क्लैरिटी और आ जाएगी, है ना।
Okay, sir. Thank you, sir. Sir, just a small question. Sir, can SOPs be patented? Standard operating procedures.
Standard operating procedures for
a particular procedure which we are doing in Ayurveda, such as therapy, but we don't have a standard operating procedure. We do it like people follow the day, whatever they wish. Like it's not, there is no standardization of any procedure. So if I wish to standardize a particular procedure, laying down some norms and aseptic precautions. So first question is this, and the second is, any teaching method can be patentized, sir? Novel teaching method.
Teaching methods तो नहीं होंगे, but when you talk about SOPs, so you will express the steps on a paper. Okay. So
Yes, sir.
you will come up with a booklet which has these SOPs
Yes, sir.
disclosed. So these kind of
Yes, sir.
these are literary works, हाँ. तो आप जब वो बुक पब्लिश करेंगे या ब्रोशर या फिर बुकलेट पब्लिश करेंगे, you have a copyright in that. So it's a copyrightable subject matter, but protection आपको कंटेंट को कैसे यूज करना है उस पर नहीं मिलेगी. The protection will be for the specific expression that you have made, है ना। जैसे टेलीफोन की डायरेक्टरीज होती थी पहले, अभी तो बहुत कम हो गई है.
Okay.
So there is one directory which is expressed in a unique form, जिसको यूज करने से आपको लगता है कि it will reduce the time to find out a number. So that kind of different or unique expression is copyrightable. तो उस लिहाज से SOPs जो आप बनाएंगे, the way you express, पेटेंट नहीं मिलेगा आपको. That is a copyrightable subject matter. You will get right on the expression. So somebody else can express that SOP again in a unique way, है ना. तो उसको फिर अलग कॉपीराइट मिल जाएगा.
Thank you, sir.
बट पेटेंट्स मिलता है इन्वेंशंस के लिए, तो आपको पहले देखना है कि whether it is an invention. तो इसलिए पेटेंट नहीं मिल पाएगा.
Yeah, good evening, sir.
Yes.
This is Dr. Damandeep Kaur. Sir, I have one question. So, in line to this question only, then we can even copyright the teaching models. Can we go for that? The models which we.
Yes. Yes.
Okay. Okay. Thank you, sir.
I have a question. I'm Dr. Soumya from Bangalore. I have done my PhD on intellectual property rights only, which is going to be blind for next in the coming this IKS also. I just want to ask you that what is the role of IKS and the role of IPR in the development of a nation? Because now we are too much technical to get the copyrights, to get the patent and all. But here the main content is IKS. So through IKS, how we can enhance our intellectual property rights?
See, the whole purpose of this session was to make you aware about the tools which exist to protect these intellectual creations. But in next 2 or 3 days, we will see how these tools can be used to protect or regulate the use of traditional knowledge. So I will request to just keep this question with you. So next 2 days will be very intellectually driven, which are based on IPR, but you will get to know how these tools are being used in PK. Or how they can be used.
Because for my further studies, I have a lot of interest about this. That's right. Thank you so much, sir.
Thank you.
Yes, sir. So it's 5 o'clock. So we can end with Shanti Mantra, and we request all of you, see you tomorrow. And if you have any queries, any questions, please write to us. We will collect all questions and come to our interactive sessions 22nd and 23rd of December. Astu, let's. सर्वे भवन्तु सुखिनः सर्वे सन्तु निरामयाः सर्वे भद्राणि पश्यन्तु मा कश्चित् दुःखभाग् भवेत् ॐ शान्ति शान्ति शान्तिः अस्तु सर प्रणमः सर्वेभ्यः
Thank you, everyone. Thank you, Kushi.
अस्तु मिलामः
Thank you, sir. Thank you, sir.
Thank you,
Thank you,
sir.
sir.
Thank you, sir.
Hello.
Thank you.
Hello. Excuse me, sir.